Hi, I'm Lonnie Acciona, owner of the divorce and family law firm Acciona Law, based in Everett, Washington. On today's podcast, we're going to talk about the intersection of family law and immigration. And I have with me immigration attorney Brandon Gillin. Hi, Brandon. Welcome to the podcast.
Hi, Lonnie. Thank you.
Hey, can you tell us, and today's podcast, we're going to talk about with Brandon, the Affidavit of Support, which is I-864. But before we jump into that, Brandon, why don't you tell us a little bit about your practice, your immigration practice? What is exactly that you do?
Yeah, so I practice immigration law exclusively. And what that means is we help people here who are seeking immigration status, such as lawful permanent residency or temporary visas, whether it's temporary work visas, student visas, visitor visas, changes of temporary visa status while in the United States. We also do other types of immigration relief, such as asylum. There's a whole bunch of other types of relief one can request while in removal or deportation proceedings, such as withholding of removal, cancellation of removal, protection under the Convention Against Torture. You can even seek a green card and citizenship while in removal proceedings. We also help companies sponsor foreign workers for not only temporary work visas, but permanent residency. So that can involve, doing what they call a perm application, which is getting the employer to recruit for the desired employee's position, which then they'd have to show that there's no qualified U.S. workers for the job, and go through a whole recruiting process and then file for a labor certificate. Anyway, we do all of that, including U.S. citizenship, of course.
And you're based in Linwood, Washington?
Yeah. I started my practice in Everett, actually, up there. I've been doing this for over 10 years. And so, I just opened my own firm in Linwood last year, right at the beginning of COVID.
Well, congratulations on opening your own firm.
Thank you.
And immigration, right? I know you're based in Linwood, but immigration is federal court.
Immigration is federal in nature.
Mm-hmm.
Yeah, so typically we deal with federal agencies like the U.S. Department of Homeland Security, U.S. State Department. When somebody's seeking benefits from abroad, to go to U.S. Embassy. That's the State Department. And then for employment matters, it's the Labor Department. There's also Immigration Court is a wing of the Department of Justice, which is then controlled by the Executive Office for Immigration Review, EOIR. And so all of those federal agencies, sometimes we can get it to federal district court. So I have to be licensed to practice in the local district court. If I want to do any federal litigation, such as, a habeas corpus or writ of mandamus or something of that nature.
Okay, so let's get right into it. What is the Affidavit of Support I-864?
So the Affidavit of Support is a form that is required in most instances where somebody is seeking lawful permanent residency, a green card. The Affidavit of Support is the way that the government will handle the intending immigrant not becoming what they call a public charge. So basically speaking, an intending immigrant can't be like a drain on society, like financially speaking. So they can't be on welfare, for example. That's just like a very simplistic way to put that. So one example would be that when, say, there's a married couple and say the U.S. citizen is petitioning for his foreign national spouse from another country, say, for example, Germany. And so that, or Canada, we get a lot of Canadians, a lot of close by. So anyway, so the foreign national has to, or the U.S. citizen petitioner has to sign this form I-864, which is a contract that they sign. And the contract is between the U.S. citizen petitioner and the government and the U.S. government. And it basically is a contract to keep the foreign national beneficiary off welfare so they don't become a public charge. And that requires the U.S. citizen to show that they have the wherewithal financially to do so. And typically that's done through income. Mm-hmm. It can also be done through assets, or it can be done through a combination of income and assets. So as an example, like an easy one would be if the U.S. citizen petitioner earned, like say $50,000 a year in W-2 wages. So that's an easy one to show because they would just be required to show their tax return for the most recent year and to show their W-2 that went along with that as the proof of income for that year. And the U.S. citizen actually doesn't have to be a U.S. citizen. It could be a green card holder petitioner. So lawful permanent residents can be sponsors as well. So they'd have to show proof of either their U.S. citizenship or proof that they're a lawful permanent resident to do this. The income standard is based upon the federal poverty guideline for the most recent year. And so the standard is that the petitioner has to show 125% of the federal poverty guideline in income or assets or a combination of the two. So typically like a family size of two, say it's just a married couple. So the family size is going to be two. That's the U.S. citizen petitioner and the foreign national spouse. It's like roughly $22,000 a year that the U.S. citizen or that the petitioner would have to show in income. And let's say the petitioner only earns, say, $15,000 a year.
Right.
What do they do? So it's just a calculation. So what you do is say it's the income is only $15,000 and the required amount is $22,000.
Okay.
So the deficiency is $7,000. So they might think, oh, I can't sponsor this person because I'm deficient.
Okay.
Well, if they have a retirement account or money in the bank, they could show if they have the deficient amount would be 7,000. They could show 7,000 times 3 in assets. That's for spouses. For other types of sponsors, like say parents or something, that have to show 5 times the difference of the deficiency. So, but in the spouse case, 3 times 7,000 times 3. If they have that amount of money in the retirement account for a period of 12 months, then they can show their bank statements, their brokerage account statements, or what have you. That would be the combination of income and assets. Sometimes petitioners don't earn anything because they are, say, students. They're young and newlywed. Maybe they're like 20 years old or something, or 21. And so in those cases, it's rare that someone like that has that kind of money in a bank. 22 times 3, that's a lot. So they would get a joint sponsor. They have the ability to get, say, like a parent or it can be a family member or a close friend, or it doesn't have to be, but somebody who's willing to jump in and be the joint sponsor. And then that person, the joint sponsor, would also have to execute their own affidavit of support and sign it and become jointly and severally liable with the petitioner on this contract.
Wow.
So, and then if they cannot find a joint sponsor, they simply cannot sponsor the intending immigrant. So it's a hard and fast requirement.
Okay.
But there are, yeah, sorry about that.
No, I was going to say, so just quick question, just I guess in terms of a recap. So if I'm the US citizen and I'm looking to bring over my fiance in Canada, who I plan on marrying, so I want to sponsor him, I have to sign this affidavit of support, basically saying that I am going to sponsor, like I'm gonna provide support for this individual. So instead of this person being on welfare, I'm going to be providing support for this non-US citizen to come in. And for me to do that, I have to at least make earnings of 20,000 per year. Is that correct?
Well, it's a little bit different for fiancés than it is for spouses. But I mean, to that, fiancés, that whole process it requires a different kind of affidavit of support. Okay. That one is actually not on the form I-864, the one we're talking about. That one actually is on a form called I-134, and it's like a temporary sort of affidavit of support that is basically only it's only to show that the U.S. citizen petitioner can keep the foreign national fiance off of welfare for the 90-day period that they're allowed to be in the U.S. then prior to the marriage, which has to occur within 90 days of their arrival in the U.S. Anyway, the I-134 is not enforceable like the I-864 is. However, as the fiance petition requires first the fiance getting that fiance visa to come to the U.S. And then, of course, 90 days, they have to get married. Once they're married, then they have to apply for adjustment of status in the U.S. green card, which does require the I-864. So eventually, once they're married, the U.S. citizen petitioner must sign that I-864.
Well, that's a good distinction to make then. The support, the I-864 has to do with this contract between the U.S. citizen who is seeking to bring in their foreign national spouse. So I guess the next question would be, what is the effect of divorce on this affidavit of support obligation, that I-64? I'm sure that's a question that you get a lot, where some people would think that I'm going to divorce this person. Can I then terminate the affidavit of support obligation? What do you tell them?
Well, it depends on when the divorce is taking place. So say there's a married couple and they're about to file paperwork for a green card, whether it's adjustment of status or maybe an immigrant relative, like a petition for alien relative to petition from someone who's abroad rather than in the U.S. If the paperwork is pending and the divorce takes place, then there's no executed contract because the executed contract comes when the green card is issued based upon all the required steps, including the affidavit of support. So if they're divorced, or divorcing, it would behoove the U.S. citizen to take affirmative steps to sort of withdraw their petition. Okay. And really, it would probably happen regardless of taking the affirmative steps, because eventually that foreign national beneficiary is going to have to appear before a U.S. government officer. And if their U.S. citizen petitioner is taking no part in it, whether in the U.S. Or from abroad, for that matter, the U.S. government officer is typically not going to approve that green card. But I always advise my clients in that situation, if you want to, avoid your obligation, you probably just need to withdraw from that. So another example, say.
Let me ask a question right here then, because I think I forgot. So when you're doing I guess the question is, when is the affidavit of support submitted? That's submitted with the petition for green card?
Mm-hmm. Yeah, so okay. It depends on if you're going to file for adjustment of status, which is filing for a green card while in the U.S., or if you're petitioning for someone who's living abroad, it's done differently. So in the US, for adjustment of status, the couple is here together. And so you submit the I-864, the affidavit of support with all the initial paperwork, the green card application.
Okay.
But it doesn't become executed until the green card is approved, which is after the interview. If the US citizen doesn't show up to the interview, there's really no way that beneficiary is going to be approved for a green card, and thereby the affidavit of support will not be executed, and that petitioner will not be subject to the contract.
That makes sense.
But if so I basically just said it. If the petitioner does show up to the interview with the foreign national beneficiary, the couple are interviewed together by the immigration service officer from Homeland Security, and the green card is approved, then the U.S. citizen petitioner is a party to that contract that's been fully executed and now is an enforceable contract. So if the divorce takes place a day later, still subject to the contract. And the divorce, even though maybe it was a one-day marriage, or not a one-day marriage, but 1 day of green card approval after, say, a longer marriage, it's enforceable nonetheless. So that brings me to the point of, so how can a U.S. citizen get out of that contract? Well, there are only 5 ways for the contracts to be terminated. Divorce is not one of those ways. The ways are, first, if the foreign national becomes a U.S. citizen.
When you say really quickly, I just want to do a really quick recap, because this is really interesting and fascinating, because since I don't do immigration, and so what I'm hearing correctly is that, so this affidavit of support I-864, right? Before the petition for green card before the application has been finalized, the contract can terminate if the U.S. citizen and their foreign national spouse, that the I-864 contract doesn't go into effect if that petition for green card has not been finalized. The application has not been finalized, correct? Okay.
That's right.
But and I find this really fascinating. Once the petition for green card application goes through, that affidavit of support kicks in. So even if, like you said, you've been married for 1 day and then you found out, let's say the foreign national actually has another marriage back in their country, or, some other circumstance that you weren't aware of, and you're like, okay, this is it. I want to get divorced. That affidavit of support, that I-64, they remain obligated to provide financial support for their foreign national spouse, right?
Yeah, that example could be a little tricky, but generally speaking, yes, that's right. Yeah.
In the big picture. Okay.
Yeah.
A summary would be, if you're able to, the only way you can, I guess, before the green card application is processed, if you decide not to go through with that, then you're not committed to provide financial support under the affidavit of support I-864. But once that green card application has been processed, it doesn't matter if you're married for 1 day or 2 days and you want to end the relationship via divorce, you're obligated to provide support under the form I-864. So, and you're going to talk about, well, it's a contract that you signed with the federal government to support the foreign national spouse, but you were going to discuss what are the ways you can terminate the contract. And you said one of them being that the green card, go ahead.
Yeah, sorry. So the petitioner has no real control over terminating the contract. There are some ways that it can be terminated, however, and so again, those ways, if the foreign national later becomes a U.S. citizen through naturalization, then the contract is then terminated. If the foreign national can be credited with 40 quarters of work, according to the Department of Labor standards there, then the contract is terminated. So typically that turns out to be roughly 10 years of full-time wages, that's taxable wages and whatnot. The third way is if the foreign national no longer is a permanent resident and has departed the US. So say they just decide to give up their green card and they're like, I just want to go back to my home country. And they've taken affirmative steps to give up their green card. There's a form you can abandon it by. And you can also, I mean, I suppose the US citizen petitioner could show that by virtue of them being outside the US for over a year, they've abandoned their green card.
Okay.
Even if no affirmative steps have been taken. The fourth way is if the foreign national is removed from the US, deported, and then later seeks permanent residency based upon a different affidavit of support. So they're sponsored by someone else. Mm-hmm. And then finally, if the foreign national dies. So those are the five ways that the contract is terminated, and it's notable that divorce is not one of those ways.
Well, let me ask, is this a way to void the I-864 contract? If I think going back to my earlier hypothetical, where let's say that I married this foreign national and the marriage was under fraud because I believed we were in love, and then I find out that my foreign national spouse is actually in love with someone else or is actually married to someone else in their home country. Can I then seek to, so in my head, you can invalidate the divorce based on grounds of fraud. And if that is granted, can you then use that to to terminate that support I-864? If you invalidate the marriage based on fraud or something?
Yeah. That's a good question, and I don't know the answer. I don't know basically how to answer that question with the case law, okay. But I believe that there is settled case law on those issues, and I don't have the citation for you. These cases have been litigated. These types of scenarios have been litigated in both federal and state courts. And across the board, in both federal and state courts, I believe almost 100% of them have said there are basically no defenses to the enforceability of the affidavit of support, which then would include like fraud marriages. And I don't quite know I don't have them in front of me, but and that's an interesting topic. There is a local attorney, Greg McLaughlin, who litigates a lot of these cases. And I think he probably knew off the top of his head.
Welcome back. I'm Lonnie Acciona of the divorce and family law firm of Acciona Law. I'm with immigration attorney, Brandon Gillin. We had a little bit of some troubleshooting issues with the internet, and Brandon is back. And where we left off, I had asked Brandon a question about, so essentially, if the family law court annuls a marriage based on a fraud, I had discussed with Brandon about then it then goes before the immigration judge. And if the immigration judge determines the marriage is a fraud or sham, deportation proceedings begins against the foreign national. And then that will then terminate the U.S. citizen's duty of support. Is that right, Brandon?
Yeah, I mean, the family court's determination of annulment is not going to affect the affidavit of support.
Yeah.
I don't think. But if U.S. immigration, like Homeland Security, gets, investigates and somehow determines that there was a fraud marriage or something, and this is kind of unlikely unless the now green card holder spouse applies for citizenship, and then they determine that she was inadmissible at the time that she got a green card because of there was a fraud marriage. I mean, it's kind of unlikely, I think. But if it were to happen, and then say that foreign national green card holder now could potentially be put into removal proceedings, maybe not. And if they are put into removal proceedings and an immigration judge then determined there was a a sham marriage, well, more than likely that person would be deported, and then it would be the former affidavit of support would be terminated. But I think the misconception a lot of U.S. citizens have is they think that they have some control over this. So they might call me and ask me, oh, I want you to help me get my former spouse deported. It's like, first of all, that's not what I do. Secondly, even if I wanted to do that, I couldn't, because I'm not law enforcement. That's like asking a prosecutor to prosecute somebody for I don't know, anything. So basically I just tell them, well, I'm not law enforcement, but there's an ICE tip line. ICE is the Immigration Customs Enforcement. It's the enforcement arm of Homeland Security. Just go online, fill out the tip line, and then that's really all you can do. It's not up to you. It's up to them to decide whether they want to pursue that person.
Okay.
So, yeah.
So you can help, and you're helping in the sense of bringing in. So again, if I'm a U.S. citizen and I'm married a foreign national and I want to bring in that foreign national, I'll reach out to you to help me with the petition for the green card application. And then what do you tell people about the affidavit of support, the I-864, when they're meeting with you about the petition for green card application?
Yeah, it's very important for me to explain the affidavit of support to both parties, because it goes along with the notion that I'm jointly representing them in this matter. So I represent the petitioner on the initial immigrant petition and the affidavit of support, those two aspects. And then on the flip side, I represent the intending immigrant on the green card application. So this is a joint representation, sort of necessary in these cases because it requires all of it to get it through. And so when I meet with people, I carefully explain to them about the affidavit of support. It's in my welcome packet. There's a whole page devoted to it. And then I just stress to them that, if there is a divorce, I have to withdraw, because then I can't continue to represent both parties anymore. It would be untenable. My loyalties would be divided. It would be a conflict of interest inherently to do so. And so if there's bickering, if there's any wind of marital breakdown, breakup, anything of that nature, calling me with complaints about the other spouse, it puts me in an untenable position, and I have to withdraw because I can't be in that position. I also explained to them what I've already talked about here, which are the 5 ways that the contract can be terminated. And I tell them in very clear terms that divorce is not one of those ways. So if there is a divorce, you're still obligated under that petition. And again, if there's a divorce, you can't call me and ask me how to protect yourself, because I would have to withdraw. You'd have to go seek out your own independent counsel at that point.
And I think that's and I'm sure that comes up all the time, that a divorce does not terminate the U.S. citizen's affidavit of support obligation.
Yeah, it's happened a few times in my practice experience, where my former clients will be married for several years, and then maybe 3 or 4 years later, I get a phone call from one of them saying that there's a divorce, and that either the petitioner, wants to get out of the contract or find ways to terminate it, or the foreign national might, ask, oh, my U.S. citizen petitioner, former husband or wife was obligated to keep me above this threshold. This, say if it was a family size of 2, roughly 22,000 a year threshold, and they have not kept me above that threshold. It's been 2 years since the divorce, and say 2 years times 20,000, they owe me $40,000. I want to sue them for that. I say, again, I can't help you with that. You might consider calling somebody else about that. Had I not been your attorney at the beginning, I might be able to help you with that. But certainly not the U.S. citizen. I don't I don't take those cases. I don't It's not that I have anything against the U.S. citizen. It's just that I would rather not do that. And the reason is because there really are no defenses to the enforceability of the contract when it's been executed. Because, like I said, both federal and state courts have been pretty decisively clear that that contract is ironclad. So, for example, a lot of these defense attorneys might get tricky with claiming like typical contract defenses for it, maybe no consideration or something like that, or
right.
Or like, oh, the former foreign national spouse didn't mitigate damages, and so that was like a big breakthrough case. That actually went to it might have been a federal court, and the question is whether the foreign national has a duty to mitigate damages.
What does that mean, mitigate? Are you saying like the foreign national spouse has a duty if the spouse is unemployed to find work?
Yeah, exactly. Okay. Yeah, exactly. And the court said no. I believe that, it was a federal court. And I think that was in the Seventh Circuit. That went to the Court of Appeals, and that was the famed Judge Posner, who came down with that decision. And no duty to mitigate damages. So the former foreign national spouse does not have to find work, even if they're like injured or just sitting on the couch. They don't need to find work. So that U.S. citizen former spouse still has the obligation to the fullest at that federal poverty guideline amount at the time the contract was executed for the number of years that's gone by.
That's a really big commitment then that U.S. spouse is undertaking in terms of that affidavit of support. Then when do you not have to submit an affidavit of support?
There are only limited circumstances where you don't have to submit an affidavit of support. I believe under the Violence Against Women Act, if you are a self-petitioner in that regard, you do not have to submit an affidavit of support. Let me just find the language here. I was wrong before, like when we previously spoke, I had thought that maybe there was victims of crimes, but I was incorrect on that. I believe victims of crimes, like for a U visa, people still have to do that. They have to find a sponsor. You don't, I mean,
so violence against women, if they're being abused by their spouse and they're exempt?
Yeah, if they were abused by their spouse, say, and then they were able to prove it there's a form called an I-360 that they'd have to submit and show evidence so that they can basically be granted that immigration benefit. They could get a green card through that I-360 approval, and they would not have the obligation there. So those people are not subject to the public charge ground of inadmissibility. It's waived for them. Yeah. So
you're talking about if they're abused by their U.S. citizen spouse.
Yes.
Okay. And was there another, if you come in on a work visa?
Yeah, employment-based applicants are also not subject to the affidavit of support. Hang on, I need to find that language. Anyway, the overarching point here is that most green card applicants are subject to the public charge ground of inadmissibility, so therefore they would have to file that affidavit of support.
Okay, so it sounds like very limited circumstances when you would not have to do that affidavit of support, which most likely doesn't apply to most of the U.S. citizens bringing in their foreign national spouse. Yeah,
so here we go. I found the language here. And so I just wanted to find the language so I can tell you exactly who is subject and who's not subject. So who is subject to so all immediate relatives of U.S. citizens, so that's spouses, unmarried children under 21, and parents of U.S. citizens who are 21 years or older. and then all family-based preference immigrants. So immigration makes a distinction between immediate relatives and preference category relatives. So preference category relatives are people like spouses of green card holders, parents of children of green card holders, married children of U.S. citizens or who are 21 or older, and then like siblings of U.S. citizens. Those are types of people who are in preference categories. They have to usually wait in line to get available visas for them in order to apply for a green card. They're all subject. And then employment-based.
They're all subject to the affidavit of support.
Yes. So, and then like a very small carve out for employment-based immigrants, where the U.S. citizen has a significant ownership in the entity that filed the petition, which is pretty rare. So the people who are not subject are those people who can be credited with 40 qualifying quarters of work in the US. So there are some people who fall into this because, say, they've had work authorization in the US for a long time. I have a client right now who was granted temporary protected status. This is from her home country, which is something that she can apply for based upon a Homeland Security designation that people from these countries deserve, like work permits and the ability to live in the U.S. They don't have to go back to the country, which maybe has some instability. They can get work cards, and that temporary protected status designation can last decades. And so in this particular person, they've had work authorization for over 10 years. They've been working, paying taxes for over 10 years. And now that person's in a position to file for a green card because of a family relationship, but she's not subject to the affidavit of support because she's already got the 40 qualifying credits.
Oh, wow.
And then there are some children who are not subject to it if they qualify for citizenship by virtue of their parents' naturalization. And then, like I said, those self-petitioning abused spouses, those types of people. And yeah, that's about it for the people who are not subject. So it's a pretty narrow carve out. Most everyone is subject.
Okay. Got it. Wow. And what's the takeaway here that you would tell the U.S. citizen then who is petitioning for this? I guess what's the takeaway you would tell the U.S. citizen about this affidavit of support that they signed?
Usually I'm not in a position to make them worried. But I have to tell them, that this is a obligation that could be potentially indefinite if one of those 5 things does not occur. So like, I usually just give them the facts. I say, divorce is not a way that's terminated. There's only 5 ways. And then I make them sign a paper saying they understand fully what their obligations are. And I don't think I've had anyone in 10 years say, like, change their mind, say, oh, I don't want to marry this person anymore. Okay. Because, they've already come to me because they want to do this. And most of them have a vague idea that they do have to financially sponsor their foreign national spouse.
Okay. Well, the takeaway, I think, would be just that if the takeaway is divorce does not terminate your financial responsibility that you, the U.S. citizen, agreed to sign by signing this affidavit of support.
Yeah.
That is
I have had situations where, say it's a young couple and the petitioner doesn't make enough money to sponsor his or her spouse.
Okay.
And so therefore that petitioner needs a joint sponsor to execute their own affidavit of support. And say that person, one of their parents does it. And I've had situations where the parents will be very concerned and say, well, I don't know about this. I don't know if I want to be obligated to support this person who maybe I've never met, or I don't like, or I don't think is a good fit for my child, and then they'll start asking me, what are my obligations under the Affidavit of Support? And that's a situation where I have to refer them out to another attorney because of the potential for a conflict of interest in the future. So as a matter of policy, immigration attorneys should never represent a primary sponsor, like the young spouse in this case, and a joint sponsor, because of the potential for divorce there. There's a divorce, there becomes a conflict of interest that's inherent in that situation. And so like immigration attorneys will frequently refer those people out. I've got a few people in my book who I just refer to regularly for joint sponsor inquiries. And we can't have anything to do with the joint sponsor. We can't talk to them. We can't advise them. We can't even look at the form they give to us. Just if it's wrong, it's wrong. If you have questions and you need help with it, you should probably talk to your own independent attorney.
Okay. So I guess just to wrap things up though, if I am the spouse, if I am the foreign national spouse and my U.S. citizen is filing a divorce for me, do I then come and see you for help with enforcing the Affidavit of Support obligation?
Sorry, can you say that one more time?
Yeah, if I'm the immigrant spouse, the foreign national spouse, my U.S. citizen husband is divorcing me, and I need someone to help me enforce this Affidavit of Support obligation, do I come and see you?
If I represented you in the green card application to that person in the green card application, then no. But yeah, if I didn't, if I have no prior history with that person, then I could potentially talk to that person about their case. Yeah, that would be the type of person that I could talk to. I typically don't, like I said, I don't talk to U.S. citizen petitioners about this issue, and just because I think that there's very little that I could do aside from maybe helping them settle a case. But again, that's not the work that I prefer to do.
Okay, so got it. So people can come to you if they're looking to if they're looking for help with petition for green card application, and they can also come to you if they are the foreign national spouse and they're looking for help to enforce this Affidavit of Support.
Mm-hmm.
So how can they get hold of you?
Oh, well, my firm is called Gillin Law Group, and we're located in Linwood, our physical offices, and we do Zoom meetings these days a lot with people, or people come in person. But anyway, my phone number is 425-947-1130, and a general email is info@gillinlaw.com. Gillin is spelled Gillin, and our website's just gillinlaw.com.
Well, thank you so much for your time, Brandon. This Affidavit of Support I-864, I feel like we only touched the tip of the iceberg. It sounds something that's really complicated, that people need to speak with an experienced immigration attorney like yourself to handle this. So thank you so much for your time, Brandon, on joining us on the Acciona Law, Divorce and Family Law podcast and how it intersects with immigration law, specifically the Affidavit of Support I-864.
Yeah, happy to be here. Thanks, Lonnie.
All right. Thank you, Brandon.
The information in this podcast is general advice only and should not in any respect be relied on as specific legal advice.